Hi, everybody. It's Katie Phang from The Katie Phang Show, doing another one of our Katie Phang lives. If you're tuning in, you're either tuning in on the Katie Phang Show account platforms, TikTok Live, Instagram Live. They didn't do it on Threads, and also on Facebook. I'm so grateful for y'all to take the time to join us, especially because if you're on the West Coast, it's a little bit on the earlier end. But for those of you that are just watching us after the fact, that's the greatest thing. You can watch us live or you can watch us as a recording because we post them later on. But I do hope you tune in live because we're also going to be taking questions. Again, we're on several platforms, but we do take questions and we try to pose them to our guests as much as we can. The goal always with a Katie Phang live is to educate and to inform. It's to go beyond the headline, to give you the information that you need. Twofold. One, so you have a better understanding about what is happening to you today in anything that we talk about. But number two, frankly, so when you also have a conversation with somebody who has an idiotic take on what the reality is, you can set them straight. That's what we do here. That's what we do on the Katie Phang Show. That's what I try to do on all my social media. So without further ado, because these gentlemen are taking time out of their very busy schedules to join us, I'm going to invite into our live. I'm going to have Ament, and I'm going to have Dan Zibel. These two gentlemen are the brilliant minds at Student Defense. They are leading the charge in some significant litigation in federal court in DC right now so that people like Elon Musk, the Doge Bros that are working for him, and the Trump administration, so they do not illegally access confidential and sensitive private information that can impact you as a student loan borrower. I borrowed student loans. I get it. And not only do I understand the breadth of information that's provided in order to secure this money, but I also know the fact that everything lives in perpetuity somewhere, somehow in the ether. And so it's kind of scary to think that people who may not be qualified, competent, or have the best intentions have access to your information. So I'm going to say hello to Aaron and to Dan. Gentlemen, say hello to everybody who's tuning in.
Hello.
Hi, thanks for having us.
Absolutely. Aaron, I want to start with you quickly. Explain to those that are watching and listening, what is Student Defense?
So Student Defense is a nonprofit organization. We work in impact litigation and advocacy, really to ensure that higher education is a launching point for economic mobility. We started the organization in 2017, shortly after the first Trump election, when we saw a real need for an impact litigation organization focused on student protections and helping students achieve economic mobility and access to college.
Gotcha. And so, Aaron, before we get into the nitty gritty on this existing litigation that we were just talking about, is Student Defense focusing just on this Doge stuff, or is Student Defense actually taking up the mantle and going to court on behalf of people in other cases?
Yeah, we have cases all across the country, largely on behalf of students who are harmed or defrauded by largely predatory institutions, or even colleges that may partner with for-profit colleges or companies operating programs. We have a case right now involving Caltech, who partnered with a for-profit company operating a short-term boot camp, but never told students that they were actually enrolled in a program that was run wholly by a for-profit college that had nothing to do with Caltech. It was a short-term cybersecurity boot camp, and students thought they were getting a Caltech education. That's just one example. Another case against the University of Southern California School of Education that defrauded the U.S. News rankings and withheld data from a large number of students that were required. So the rankings shot up, and they partnered with a for-profit company called 2U to recruit students into these online programs with a false ranking. So those are just a few examples of cases that we have across the country as well.
So Dan Zibel, Dan, why don't you tell people right now, what is this lawsuit that was brought in federal court vis-a-vis Doge and improper access by Doge?
Sure, Katie. Well, look, the Department of Education collects student data with a promise to keep it safe and to use it to help students secure financial aid and make informed decisions about their future. we know that about 42 million Americans have given that sorts of information to the department. It's personal, financial, bank account numbers, social security numbers to the Department of Education. And what we also know is that DOGE has gotten access to that information. We don't know what kind of oversight. We don't know what they're doing with that information. But so we represent the UC Students Association, which is a nonprofit with over 230,000 members who are undergraduates at the University of California system. These are students who, I think more than about 70% of them receive some form of federal financial aid, meaning that their information has been provided to the Department of Education. And what the lawsuit is about is really making sure that the Department of Education is following the law. The Privacy Act, the Internal Revenue Code are two statutes enacted by Congress that protects this information. This is incredibly detailed and important information to folks, and we want to make sure that the Department of Education is simply following the law and treating that information with the security and the privacy interests at stake.
So I'm glad that we're talking about this, Dan, because it's, as I stated at the beginning, it's terrifying to think that people that may not have the best intentions or even have the competency to be able to have access to the information have access. For those of you that are tuning in, Student Defense brought this litigation in federal court and successfully obtained what we call a preliminary injunction or a temporary restraining order. Some people kind of know restraining orders in the context of domestic violence cases, et cetera, but they do live in civil land, as I say. And it basically puts a block or a pause on the ability for a party to be able to do something. So, Dan, you guys got this temporary restraining order where a federal judge told DOGE and the Trump administration, you cannot continue to access this information. But I guess the first question I have, Dan, would be this. How much reassurance did you receive in any capacity from the other side, from DOGE, for example, before this temporary injunction was put into place by the federal judge about what they had been able to access already?
So, Katie, I want to be just one thing I want to be, I think, crystal clear about for folks is that what's happened in the litigation is that we had an agreement in place with the department pretty quickly after filing our lawsuit, which the judge entered as an order, which prohibited the department from disclosing the information in all the ways that we were concerned about. We then filed what you were referring to as the motion for temporary restraining order, and that's what the judge actually denied a couple of days ago. So there was an order in place blocking the access to the information, and then as I'm seeing, as your headline is showing right there, on Monday the judge said, sort of lifted that order. The case remains very much alive, and we are very much continuing to pursue to make sure that the department keeps the protections in place. But that is just sort of the procedural status of the case right now. And I just wanted to, just in the interest of making sure that folks know what's going on here.
No, and I appreciate that. So, Dan, let me stop you there. So why, if the administration was willing to enter into that temporary agreement with you without even a judge ordering them to do it, why would they? Why was there an expiration on that agreement? Like what basically was the trigger point to make that agreement cease to be in existence with them?
I think it was really to let the judge take the time to look at the temporary restraining order briefing that was filed. It wasn't a long period of time. It was a number of days where if you looked at the papers that were written up in the matter of 72 hours, I think, with us and our co-counsel and the folks at the Department of Justice, there was a lot of ink spent in a very short amount of time to give the judge some sense of what's going on. And I think one of the difficult things, as we were talking about before, is that the facts are, it's a black box to the outside world. It's a black box to us to know exactly what's happening at the department, and it's a black box to the judge to know exactly what's happening at the department. And I think that's something that if you were listening at oral argument last week when we were in front of the court, Judge Moss was incredibly concerned about the fact that we don't truly know what's going on other than DOGE and some affiliates of, some DOGE affiliated individuals have some amount of access. And look, we don't even really know what any of that means and what is DOGE and who's running DOGE and who's, who these folks are taking their direction from.
Yeah, so Aaron, based upon what Dan has said, why do you think, and what was maybe kind of the rationale from the federal judge, if this black box of information, which is kind of an irony kind of to say, right? If there's this black box of information where it's the federal government. So putting aside, my argument is always DOJ is not a legit congressionally created agency, right? I don't even know what DOJ is. But assuming argument you can call it a government agency, Aaron, it's like they have the burden for transparency to the American public. If they're not able to answer basic questions to the federal judge about who's accessing what, when, how, whatever, why is the federal judge reluctant at this point to bar the DOJ people from having access to this information?
Yeah, Katie. So to get a temporary restraining order or preliminary injunction, you have to show what's called irreparable harm. That the students, that the plaintiffs have been harmed in a way that's sort of irreversible. Now, the judge, I think, has indicated he's really troubled by the government's inability to answer basic questions as to, who has access to the data, what it's being used for, and has indicated that he may be open to us taking discovery at an earlier stage. That's sort of unusual in an Administrative Procedure Act case. And I think that's really important because, we all live in this digital age. And once, information has hit the internet, once your private confidential information is out there in the public, you can't really get the toothpaste back in the tube, right? And the basic facts that we do know so far that, DOJ has had one of their early team members already lose a laptop in the first few weeks. We don't know what data was on that laptop, but that, the New York Times has reported that a DOJ member has lost a laptop. They have already filed a declaration, I think Sunday night in our litigation, or Monday night, that one of the DOJ team members has not taken the proper cybersecurity screenings and trainings or ethics trainings required. So, these are all things I think that are, heightening concern. There was a New York Times story about their desire or plans to run some of this data through different AI models. I think it's unclear where that's being housed, what platform that's on, what is the intended use of that. All things that I think are also alarming to the judge. He's indicated, that the door might be open now to find that information. I think once we get some facts in the record that are showing, there is harm occurring right now, we might be back in court pretty quickly, trying to get an order protecting students.
Yeah, Dan, I think it's for people to realize that just because the federal judge right now says, I'm not going to block something from happening, doesn't mean that as the record is developed, and the record being evidence that is admitted, answers to, questions under oath provided in writing, et cetera, in production of documents, once there's actual evidence that's produced during the course of your litigation against the government, then the judge may be inclined to say DOJ is blocked from access it. But I guess everybody, including myself, is always going to say, okay, but to Aaron's point, what's out there is going to be out there. What's been accessed has been accessed. How do you put that back in, and how do you protect people moving forward?
Well, I think that's exactly right, and that's the cause of our real concern is that, as Aaron said, you can't put the toothpaste back in the tube. And I think one of the other questions that that I think lots of people have is, and Aaron was alluding to it, is why? Like, what are they doing with this information? Why do they have it? They've talked a little bit in our the declarations that have been submitted in this case about protecting protecting the government from waste, fraud, and abuse. Well, what does that mean, and why is it that they need Jane Doe, who submitted a declaration in our case? Why do they need her bank account information if they're looking at waste, fraud, and abuse across the government? One of the other interesting things, Katie, is that President Trump was asked about DOJ access to Treasury Department information and the Treasury payment system, and there's ongoing litigation about that too. And he was asked, why does DOJ need this kind of personal information? And his response was quite telling. He said, well, they don't. And that's, I think we actually agree with that. There's just no reason why, if you're trying to look at, big programmatic changes or trying to make sure that the federal student aid systems are working efficiently and working well, why is it that you need this kind of incredibly individualized information about, students and their families at sort of that granular level is incredibly concerning to us.
So, Aaron, my question then to you is, based upon what Dan has just said, Um, there's other litigation that's going on about which student defense may not be involved in other jurisdictions involving Doge. Is there a way to kind of reconcile the representations that are being made under oath in those other courtrooms or in those other proceedings to basically show that Doge either doesn't know what the hell they're doing or is making affirmative misrepresentations about access and the reasoning behind why they're doing what they're doing?
Yeah, we're in close contact with several of the litigators and organizations involved in the lawsuits in context with other agencies and Doge access to personal confidential information. And I think it might be very telling when facts in one of these cases come out about improper use and, the failure to abide by proper security protocols. It's unclear, especially for tax information and personal information that student borrowers or taxpayers fill out when a student applies for a FAFSA. You put down your social security number, your birth date, address, all confidential information. The department also has, tax information that you need, heightened security clearances to gain access to. It's unclear, who gave these Doge team members proper clearances, if any. And I think as information comes out through discovery, through affidavits and other litigation, it could become very important to our case as well.
Yeah, we have a viewer question, and it's one that applies to anybody who's listening. As a student loan borrower, is there anything that can be done? If the government gets my info, do I have any power here? I guess if I can maybe give a little bit of a spin on that question for you, Dan, I guess if you are a student loan borrower, what should you be doing? Should you be contacting student defense? Is this just a California thing? Like what should they be doing, do you think?
I think, unfortunately, there's not a ton that students can be doing right now, other than the same things that I would, urge people to do, students and non-students, as relates to personal information, which is, periodic checking of their credit report, trying to do what they can to make sure that, again, to borrow Aaron's analogy, that if the toothpaste has left the tube, trying to contain it as much you can, even if you can't put it back. So, monitor your credit reports and the like. And what we're hopeful for is that, the department will be following the law, taking its obligations under the Privacy Act and the Internal Revenue Code seriously, and that this doesn't have the effect of, discouraging people from applying for the financial aid that they're entitled to.
Aaron, I guess then, if the issue in terms of irreparable harm, meaning can't fix the harm that's been done so far, if the issue of irreparable harm maybe kind of remains open and amorphous for purposes of your case, does it seem like, unfortunately, then that somebody's privacy has to be violated? Like the damage has to be done for somebody then for a judge to say we have to stop the way this is being done?
No, Katie. So I think the case law is actually pretty clear that this violation of privacy, if a protected privacy interest, does suffice harm. For Article 3 standing for students to allege that they were harmed. What the standard for irreparable harm is just for an emergency order that we've been seeking. I think that may become pretty clear in the record that there are facts that suffice irreparable harm very soon. One thing I think, we could tell students, if you do have knowledge that your information has been out there, that you've been subject to sort of identity theft or harm already, you can contact us at our website, defendstudents.org. But as we sort of develop more facts in the case, we'll be sort of revisiting, whether there's the ability to get another emergency order in place.
And Dan, there's two different theories that your litigation is traveling under, one of which is a violation of the Privacy Act. And you mentioned the Internal Revenue Code. How would that actually come into play vis-a-vis this type of case?
Sure. Well, as part of the FAFSA, the application that folks fill out to get student financial aid, there's a process by which tax information can be imported directly from the IRS into the FAFSA to make it easier for students to apply for financial aid. And so at that point in time, the information is tax information that is protected by some of the privacy laws in the Internal Revenue Code. Look, it's important to note these are really serious laws, right?
Yeah.
There are civil penalties. There's possible criminal laws at stake here for people who knowingly violate these privacy laws. That's how serious these statutes are, and that's just really important to make sure that the government is taking these issues seriously.
Aaron, we saw a declaration by the Trump administration in another case wherein the gentleman who did that declaration, and that's under penalties of perjury, right? That declaration made a representation that Elon Musk is not running Doge. And it kind of then begs the next question. So if he's not running Doge, which is a representation that's been made by the President of the United States and others, who is running this organization? Have you guys obtained any type of representations in your own case about who's actually the supervisor of these people that are running amok, accessing people's private information?
Katie, it's a great question. Even in our case, there's declarations as to 6 people that they claim have access to the data, that there are several who, or at least one who filed a declaration almost identically in, I think, the Department of Labor case, that, these people who claim they can have access to this data because they're Department of Education employees, but they're making the same claims that they're employees of other organizations, that they're on detail to multiple organizations across the government or multiple agencies. I think the judge has been indicated, at least he's pretty skeptical of this claim that you can be an employee of, dozens of agencies at once. I mean, can Elon Musk show up for 5 minutes at one agency and claim to be an employee, for purposes of gaining access to, confidential records or tax information? This is often data that, people at the highest levels, the, heads of these agencies don't have access to. That's how serious the security clearances are for tax data of individuals. So I think, these are all questions that we really still have no answers to.
And then, Dan, the lawsuit's currently being brought against the acting Secretary of Education. Her name is Denise Carter, and against the Department of Education. Because I know people have asked me this, Elon Musk, for example, is now being sued in his individual capacity. In some other cases, is it possible that as your case proceeds and you and Aaron get more evidence through the discovery process, that there could be more people added to your lawsuit that you're going to sue, including somebody like Elon Musk?
I think anything is possible, Katie. I certainly don't want to.
That's a great lawyer answer, by the way.
Anything is possible.
Looking like
the
a good
facts
lawyer.
are so, as we've been saying, the facts are so just shifting as we've learned more. But right now, our case, as you say, is against Denise Carter in her capacity as the acting Secretary of Education.
Gotcha. So
and
for
the
everybody
department itself.
And so for everybody who's tuning in, I heard the website before. I'm going to repeat it again. You can go to defensestudents.org. That is the website for Student Defense, the organization that is currently suing, as we just heard, the acting Secretary of Education and the Department of Education on behalf of the University of California Student Association, about 230,000 members. You guys are representing to try to protect the confidential information of student loan borrowers. I want to thank Aaron Ament and Dan Zibel from Student Defense for joining us today for this Katie Phang Live. I invite you guys at any time to come back here or on the show to talk about the status of your litigation. I always say there's a group of lawyers called the enablers. I'm a big believer that if there weren't the lawyers that were helping Trump and others to do this stuff, that there was a lot that they couldn't get done. So I'm upset at the people that are enablers, but you guys are not. You guys are the helpers. They always say, find the helpers, and you guys are doing what I say is the Lord's work. So continue on the good fight. Folks, go to defensestudents.org. Check out that website. Get information. Be informed. Thanks, Aaron. Thanks, Dan, for joining me today. I appreciate it.
Great. Thanks so much
for having us.
Bye, guys. Thanks.
Bye.